Hey, if you're a nonprofit or you're not making a lot of money, can you use somebody else's work just because it's fair use? Just because it seems fair? Or because you found it on the internet? Is that fair use? No. Stay tuned. So, one of the questions that we get all the time here at the Screen Lawyer is this notion of fair use in the copyright world. People have heard it. It is a long recognized concept, doctrine in copyright law. And it functions in a way to allow certain types of uses of work that would otherwise be copyright infringement. And it's because certain types of uses are protected by the First Amendment to our Constitution. It's a very important distinction, and it's been well developed over many, many years by lots and lots and lots of cases. The challenge is this. It isn't a bright line rule. There isn't an automatic, if I do this, it's fair use, and if I don't, it's not. People ask me all the time, well, I'm a nonprofit, or I'm a school. That means I can use things fair use. And my answer is maybe, but you still have to go through the factors. So I want to tell you a little bit about the 4 factors very briefly, and then we can get into more detail later. You can look some things up. But fair use is essentially this. It is a defense to copyright infringement. You are using somebody else's copyrighted work in your work, and you do not have their permission. That alone, right there, that's infringing the rights of the copyright holder. But if, under certain circumstances, it's going to be okay under fair use. So you are copying their work without their permission. The only question is it permissible? And really what it comes down to is this, 9 times out of 10 it's this. There's 4 factors, but there's one that's going to matter the most. And that is, what are you doing with the other person's work? And it's actually very limited. The nature and character of your use is what matters. And it's fairly limited. You can use it for criticism, commentary, teaching, scholarship, research. That's pretty much it. Now, the courts talk about it in a lot of different ways, but basically what it amounts to is you can use someone else's work to do something about the work. You can talk about the work. You can repurpose it in a way that uses it in a different way by making a commentary on that work. That's the key. So parody and certain things like that, satire, sometimes they pass the fair use, but it's a tough test. But if you want to have a review site, you want to say, I like this movie, I don't like that movie, and you want to show a clip of the movie, by showing a clip from that movie, you are infringing the copyright in the film. But you're permitted to do that if you want to talk about it and say it's a good film, bad film, otherwise. The nature and character of what you're doing with the work is key. 2 other factors that come into play. One is, did you only use as much of the work as is necessary to make your point? You can't use the whole, the review site can't say, well, let's watch this 90-minute film together, I've pirated it, and then I'll tell you whether I like it or not. But you can certainly show a 90-second clip. And that ties in with the next factor, and that is, does your use have a negative impact on the commercial market for the original? So think of our movie example again. If I'm showing a 90-second clip, now if I say it's really bad and people agree with me, they may not go to the movie, but I can do that. But my showing of that 90-second clip isn't going to make people say, well, now I've seen 90 seconds, I don't have to go watch the other 89.5 minutes, because that doesn't have any impact on the commercial. The use of the clip does not itself have any impact on the market for the original. Those things all kind of go together. But the key is going to be this one. What are you doing with the work? And that gets back to things that we talk about in copyright law all the time. What are you going to do with what it is that you're getting determines what types of contracts you need, whether you need permissions, whether the scope of your releases is big enough for the use that you have, all these different things. You always have to think about what it is that you're going to do with the work. back to the school question. If I'm a school and I'm a teacher and I want to reproduce 12 copies of a work to give to my students to then educate and talk about that work, that's fair use. If I'm that same school and I want to take that original and I want to put it on our school bookstore and sell a whole bunch of copies of it, I can't do that because that's a commercial use. And that's one of the big keys here. Basically, if you are using someone else's work for a commercial purpose, the purpose of your use is to sell something else, you're going to need permission. It's not going to be fair use. So, if you're interested in more information about fair use, there's lots of resources you can Google. Stanford Law School actually has a really good site that collects a lot of this information. You can check that out there. And I'm sure we'll be talking about this at the Screen Lawyer again and again because it's a complicated and interesting issue. But just remember, you've got to think about the nature of your use and you've got to be commenting on the original in some way. Otherwise, you're going to need their permission. Take care.